Hello, I'm David Rubin from Nutter, McLennan and Fish. I'm here with my partners, Chris Lindstrom, Emily Fox, and Natalie Capilazzo. We all practice in the firm's Labor and Employment and Benefits Practice Group. And we are very glad you're joining us here today. Thank you so much to talk about considerations for employers on returning to work amid COVID. Why don't we switch the slide, Natalie? Thank you. We've broken our program up into 4 parts, conveniently enough, because there are 4 of us. So first, Emily is going to talk about screening, testing, and guidelines for exposure. I'm going to talk about ADA and OSHA compliance. Chris is going to talk about remote working considerations, and then Natalie is going to talk about the Families First Coronavirus Response Act entitlements. These subjects really overlap a lot, so I think you'll see that in the course of our discussion. And we've tried to build in enough time for questions during and or after. So if you have questions, please put them in through the Q&A tab. With that, I am going to turn this over to Emily to talk about screening, testing, and guidelines for exposures. Emily?
Hi, everybody. I'm Emily Fox. And just to start off, all of you probably are aware of this already, but just to go over again, in order to reopen as a brick and mortar business with folks coming into the office, every business has to create a COVID-19 control plan and fill out a compliance attestation form. Those forms are available on the mass.gov website. And generally in the control plan, every business has to address the Commonwealth's mandatory safety standards for their specific industry. And while each industry, and it's pretty specific how they break down the businesses, but generally each business has to cover social distancing measures. That includes kind of building occupancy, staying 6 feet apart, etc. Hygiene protocols, such as having hand sanitizer and encouraging hand washing, staffing and operations, staggered schedules, that sort of thing. And also the screening that we'll talk about shortly, and then cleaning and disinfecting every day, and in the case of a positive COVID case, shutting down the whole facility. And then again, detailed safety standards by business type are available at the mass.gov website. It's a little unwieldy, so if you have any questions, definitely reach out. Screening and testing. So in the safety standards that set out by Governor Baker and the Commonwealth, every business is required before every employee comes into work to screen employees to ensure that the worker's not experiencing any COVID symptoms themselves. You're probably very familiar with them, but new loss of taste or smell, fever, cough, sore throat, etc. The worker has not had close contact with a positive COVID-19 case. And the Commonwealth's guidance defines close contact as living in a house with somebody who's positive for COVID, caring for a person who is positive for COVID, being within 6 feet for 15 minutes or more of a positive case, and being in direct contact with secretions from someone while they're symptomatic. And I was just talking to everybody earlier, the CDC yesterday evening just revised their definition of close contact to being within 6 feet of a positive case for a total of 15 minutes over 24 hours. So I'm sure that's going to cause a lot of angst over the next few weeks as people try to deal with that, and that's going to make contact tracing a lot harder too. But right now, these 3 issues must be screened for every employee prior to their day. Many employers have been asking about travel as well. It's okay to do that. You're probably familiar with Governor Baker's travel order at this point, requiring every traveler into the state, including Massachusetts residents, to either quarantine for 14 days or produce a negative COVID test. Before I move on to this topic, employers are doing the screening a lot of different ways. Some employers are requiring employees to, fill out a paper attestation form. Some people have apps. There's a lot of different ways you can fulfill that requirement. What do you do if an employee showing symptoms or has exposure to a confirmed positive case? In the first instance, if they fail any of those questions that we just discussed, they must go home immediately or not come to work, of course. And the employer should go about investigating that worker's close contacts in the 48 hours prior to their showing symptoms. In any event, in the event of a positive case, employers have to notify their local Board of Health and shut down their site for deep cleaning and disinfecting. And the guidelines are pretty vague as to what to do after that. Essentially, the local Board of Health will tell you what to do. And they're going to tell you, they're going to help you with contact tracing, tell you who needs to stay home in quarantine and who doesn't. And that can be really helpful just from an employer standpoint of having, the local Board of Health kind of ordering you to do this instead of it being just your decision. If you have an employee that has tested positive, in order to have them come back to work, an employer can require them to produce a negative COVID test, a doctor's note, a certain time period without showing symptoms, or they can require an employee to quarantine. I've had a lot of questions about doctor's notes in various circumstances. The CDC discourages employers requiring doctor's notes to return. Really on the basis that doctors' offices are kind of inundated right now, and it might be very difficult to obtain such a note. And just to kind of give you a background of the legal basis for this, if you're wondering, can I do this? Can I require this employee to produce a negative test or a doctor's note, say that they got exposed outside of work, then they had like a rapid negative test or something like that right away, and you're nervous about them coming back to work. The direct threat analysis under the Americans with Disabilities Act is that an employer may require testing where it believes the employee's medical condition would either impair his ability to perform essential job functions or pose a direct threat to safety in the workplace, and that is would pose a significant risk of substantial harm. And the belief must be reasonable and based on objective evidence. So if you're kind of thinking through what you may or may not be able to ask employees to do, in this situation, a lot of COVID is considered a direct threat. So there's a lot more latitude to ask these types of questions than there normally would be. We've also got a lot of questions about when employees can return to work. As always, follow the local Board of Health guidance as to who needs to stay home and who can come back. The CDC has different types of guidance for the type of worker the employee is. So the essential critical infrastructure workers have a different set of guidelines in the case of exposure to a confirmed positive. So, but here, just your regular worker who has a confirmed or suspected positive case and showing symptoms, they can be around others after 10 days since symptoms have appeared, 24 hours fever without the use of fever-reducing medication, and if other symptoms of COVID are improving. They used to have a test-based strategy. So another way that you could say an employee come back to work is if they got 2 negative COVID tests in a certain period of time. That's no longer recommended. They recommend the symptom-based strategy. For someone who has a positive test but is asymptomatic, they can be around others after 10 days have passed since their positive test. And then a close contact with somebody is for quarantine. The CDC recommends quarantining for 14 days after the last exposure. So in some cases, somebody who was exposed to a positive person may need to stay home longer than someone who actually was diagnosed with the disease. Right, as I mentioned, there's different guidance for essential critical infrastructure workers. They that, because you need these employees to be working at these essential jobs, if exposed to a positive case, you can still come to work. You just do wear a mask, take your temperature before coming to work each day, monitor your symptoms per day, and maintain social distancing. The guidelines are the same if the employee actually tests positive. You stay home and self-isolate under the other guidelines. And as I mentioned, the local board of health is going to help you out with this. If they say that your employees need to stay home, even if they are critical infrastructure workers, that's a local order. And as Natalie will talk about, the local order renders those employees eligible for the family's first emergency sick leave provisions. That is all I have on the screening, testing, and exposure guide. I'm going to pass it off to David.
Thank you, Emily. So first we're going to talk about, we're going to go up the ADA and OSHA together. And so let's start with the ADA. And, as a general matter, I think most of us know that Americans with Disabilities Act provides that employers cannot discriminate against disabled employees who are otherwise qualified to perform the essential functions of their job. And it imposes on an employer an obligation to provide a reasonable accommodation, if necessary, that would permit that employee or a disabled employee to perform the essential functions of the job. That analysis is, what we're all pretty used to, and is what 99% of the cases that we've had historically in questions have involved. But there is another provision in the Americans with Disabilities Act, and it's funny. It almost seems like it was it's sort of like a footnote, but there's provisions in the Act that say that employers cannot perform disability-related inquiries or medical examinations of employees. And that's very broad, a disability-related inquiry or medical examination. What would be a disability-related inquiry? You can't ask an employee if he or she has asthma or AIDS, or if they're immunocompromised. Medical examinations can cover all kinds of things, very broad, including taking employees' temperatures. So we have these prohibitions on an employer's effort to inquire of employees about their medical condition and to test employees about their medical condition. This originally came up back in the SARS pandemic, and I lose track of time now, but that was some time ago. And EEOC passed some or issued some guidance at that time about when it would be permissible to conduct tests and conduct medical examinations, and it was very limited at that time. But now, of course, all bets are off, right? Because the coronavirus has exceeded SARS so dramatically in terms of its effect on the workplace and its effect on American industry. So early on in the process, the Equal Employment Opportunity Commission said that because having COVID-19 in the workplace would present a direct threat to the safety and health of employees, and Emily, if you'd switch that slide, that would be great. Because having COVID-19 in the workplace would create a direct threat to the safety and health of employees, that means that employers can make certain inquiries and medical exams to determine if employees have COVID-19 before they enter work. Again, the analysis, and I think, and Emily touched on it. Oh, if you could go back again, sorry. I think Emily touched on it, and that is, it's an exception when there is when an employee's health condition presents a significant threat to the health and safety of the employee at work. You know, that's come up. You might have encountered that in the past, where you become aware that an employee has some kind of medical situation or circumstance that is somehow jeopardizing his or her health in the workplace. And you've observed it. You have some objective evidence to observe that it's the case. And in those instances, you've been permitted to make these inquiries. Well, essentially, the EEOC made this sort of blanket statement right up front that because COVID-19 presents a significant risk of substantial harm to the health or safety of employees that cannot be eliminated by reasonable accommodation, then in that case, because of that, employers can take temperature scans and make other COVID-19 inquiries. And as we know from the state guidelines and the CDC guidelines that Emily just talked about, in fact, you really have to make those kinds of inquiries as employees enter the facility. This will go on, presumably, you know, this exception will go on, we assume, for as long as the pandemic presents this threat. At some point, again, presumably, that authorization will be withdrawn by the EEOC to make those kinds of inquiries and to do the temperature scans. Emily, if we want to go next now. So while having COVID-19 in the workplace has been recognized to be a direct threat to the health and safety of employees, those high-risk medical conditions that make you vulnerable or make a person vulnerable to COVID-19 have not necessarily been recognized as presenting a direct threat to an employee. So, and this is a question that's come up time and again, it continues to come up, and that is, you know, can we ask our employees, do you have asthma? You know, are you immunocompromised? And right now the answer is no. You're not allowed to ask that question. And you're not allowed to single out those employees who you know have asthma or you know have some specific condition that would make them compromised. Similarly, you know, individuals who are age 60, 65 and older have been deemed, you know, high risk or more vulnerable to the virus. You can't single them out for special treatment either. What you can do is you can tell employees that, you know, about this, as you're telling employees about the steps you've taken to deal with COVID-19 and coronavirus in the workplace, and with regard to your safety measures, you can invite them to come forward if they believe they have one of those conditions that may render them high risk, and that the company would be, you know, certainly willing to look at all types of reasonable accommodations that may be necessary to accommodate the employee. You know, so by, you know, inviting that kind of response rather than asking the question is going to be, I believe, permissible under the ADA. Next one. The other piece of the other part of the ADA that we should talk about here is the rule in the ADA that says all employee medical information must be kept confidential. Actually, the ADA doesn't say it quite that explicitly or specifically, but the EEOC has interpreted it as such, meaning that any medical information that the employer has related to an employee has to be kept confidential, has to be maintained separately from personnel records. And disclosure of that information can only be made to very certain prescribed individuals, namely supervisors and managers who are going to determine work restrictions or decide on what accommodations are possible, to those employees in the workplace who are responsible for first aid and safety, and to government officials who are enforcing the ADA or investigating ADA compliance. So, of course, that issue has come up repeatedly when it becomes known to the employer that an employee has had COVID and you need to be able to disclose to other employees, that they may have been exposed. Can you tell the employees that, that Joe came to work on Thursday and we understand he's been COVID positive, so you all need to get tested? No, you can't tell them about, that it was Joe. That would be deemed a violation of the ADA confidentiality rule. You can say that an individual who was in the workplace on Thursday between the hours of 8 and 7 and worked in this area and may have been in the break room at certain times, tested positive, and to get that kind of notice. And I know the question has come up repeatedly, and I've been asked it a number of times, that people are going to know. They, especially in a small workplace, or if the information is specific enough, that people are going to be able to figure out who it is. So be it. That's not going to violate the ADA confidentiality rule, so long as you're not telling them who that specific person is, but rather you're giving them enough information so that they can make a reasonable determination as to whether they may have been exposed. That's really your objective. So, as we try to navigate all of these rules, the CDC rules, the state opening rules, all the rest, we also have to navigate these ADA rules regarding confidentiality, medical exams, medical inquiries, etc. And it doesn't get any easier, I think, as we'll go see on the next slide. Because that brings us to OSHA. So as you may or may not have heard and read, OSHA has not, the US OSHA, the Occupational Safety Health Administration, which administers the Occupational Safety and Health Act, both are OSHA, so it's always confusing, but the administration has not enacted any specific COVID standards. There are no OSHA COVID specific regulations. And they've been very much criticized for that fact by a number of groups, especially, organized labor. But OSHA has not done that. There have been a couple of states that have already done so. I know Virginia and Michigan, their OSHA laws have been specifically, their OSHA organizations, agencies have passed specific regulations in terms of addressing addressing COVID. But the federal OSHA has not. Instead, and if we can turn the page, OSHA has relied on what they call their general duty standard. And that is the sort of the cornerstone of OSHA is that all employers have a general duty to provide a workplace that's free of known serious hazards that can be feasibly mitigated. OSHA has said, that they're relying on the general duty rule to regulate COVID safety under OSHA going forward, under the Act going forward. And OSHA has specifically said that COVID-19 is considered a serious hazard subject to the general duty obligation, meaning that employers have a general duty to provide a workplace free of COVID, or at least that is made as safe as possible with regard to COVID. And some highly publicized cases over the last month, really in the month of September mostly, OSHA, the administration, has issued fines to a number of employers, particularly in the meatpacking industry that suffered serious illnesses and death rates early on in the crisis, essentially saying they had no rules in effect. They didn't require social distancing or masks, or they never looked at any particular policies or protocols that might protect employees from exposure. And of course, once exposure comes up in the workplace, it just gets worse. It snowballs, and that's what happened in these meatpacking facilities. So they have been fined. They also issued a number of fines in the healthcare industry. And healthcare employers are subject to some additional regulations about PPE that including respirators and gowns, etc. And those healthcare employers that did not provide that PPE or did not make it available were cited as well when employees became struck by COVID, and again, had that snowballing effect in a number of these different facilities. If we can switch the page. Excuse me. Thank you. So how do we comply with the general duty standard? Well, I mean, as I see the general duty standard, essentially what OSHA is saying is they're not going to pass the regulations. They're going to rely on everyone else to do that. So what we just heard from Emily, that quite frankly is the general duty standard for most employers, as far as we can tell. That is, you need to comply at a minimum with your own state and local opening and operating rules, and at a minimum with the CDC guidance. So if, in order to ensure that you're in compliance, you need to develop a written plan for opening and operating, comply with all existing industry safety rules, state and local operating requirements, all of the issues regarding screening, social distancing, cleaning. You need to consider remote work and allow it where applicable, stagger shifts where appropriate, conform to CDC guidance. All of those same things that we've been talking about all along and that Emily went through, that's really the key to complying with the OSHA's general duty standard. I think in Massachusetts, in some ways, it's easier, right? Because Massachusetts has been pretty rigorous and pretty stringent in their reopening and operating rules, even though there are still questions in vague areas. But we know that there are other states that have virtually no rules. And it will not be enough in those states, I believe, to say, oh, well, there's nothing for the state requirement. Let me back up, say this again. It won't be a defense to say, hey, the state doesn't require us to do anything, so we're not. I don't think that's going to be a defense against an OSHA claim or against an OSHA fine. So in any event, I don't believe OSHA requires us to do anything more than we're currently doing under the Massachusetts and CDC guidelines. That may not always be the case in some other states, I guess is my point. I think there's another slide or two here. So then that brings us to the OSHA 300 log. So as most of you know, or may know, I assume, that employers have an obligation to record work-related injuries or illnesses. If it results in hospitalization, or death, or if it arises in the workplace, if it involves an absence, I think of 3 days or more, but I'd have to double check that. But in any event, this is the typical rule about recording your OSHA illness and injuries. OSHA, the administration, has said that COVID-19 is a recordable illness if it's work-related. And to be work-related means that it had to arise from someone being exposed to it in the workplace. So how do you know if someone was exposed to it in the workplace? Well, back in May, the OSHA administration issued some guidance saying that the employer must conduct a reasonable investigation into the work-relatedness of a COVID case. So if an employer learns that one of its employees has COVID, the employer must conduct a reasonable investigation into whether it's work-related. Presumably that means you need to talk to the employee and say, is there any place you can think of where you may have been exposed to COVID, either at work or elsewhere? I mean, but you're still subject to the ADA restrictions on medical inquiries. So you have to be somewhat circumspect in asking questions. One question you can't ask, and this again is extremely frustrating, you can't ask the employee, do any of your family members have COVID? That would be deemed a violation potentially of the ADA, but of the Genetic Information Non-Discrimination Act, GINA, which was passed, I think about 12 or 13 years ago. I've never had a case under it. I've never had an issue arise under it. And yet the EEOC has been telling employers that you can't ask that question. With respect to COVID, you can't ask an employee whether or not any of the employee's family members have COVID, which is of course going to make your investigation into work relatedness that much more difficult. So I guess the question is, do you know whether or not you've been exposed to anyone outside of work that has been diagnosed with COVID? And then if you determine that, that the infection arose that was work related and was resulted from exposure in the workplace, well, that obviously means you have someone else who has been in the workplace with COVID, and you'll have to jump through those steps that Emily talked about when you do have a positive in the workplace. But if you determine that it isn't, or that it was likely not, because you know that the person was exposed to someone outside of the workplace with COVID, then you don't have to record it. And if you can't make a reasonable good faith decision, that is, you can't tell, you have no basis to say one way or the other. If the employee says, I don't know who had COVID that I was exposed to. I came to work every day. I've gone grocery shopping. I've worn my mask. I don't know of anyone that I'm deal with that has been tested positive, but I don't know. In that case, you can't make that determination that it was more or less likely to have been work related. And in those cases, you don't have to record it. That's what OSHA has said to employers. I think that's our last page here. So I'm going to turn it over to Chris now to talk about issues arising with regard to remote work.
Thanks, David. And before I start, we did have one question that I wanted to ask you. If a COVID illness could be considered work-related, how does workman's comp play into that? In terms of, can there be a claim if someone, and presumably if the employee can prove that he or she was infected at work?
And as you know, because we've discussed this before, this is one of my favorite subjects. But so workers' comp historically has said that work-related illnesses are only compensable under workers' comp when the illness was somehow, and I forget the word they use, but it's somehow intrinsic to the workplace. So that a coal miner who develops black lung will be eligible to recover workers' comp because black lung is intrinsic to that specific industry. An accountant who develops black lung, less likely so. Someone who gets the flu from someone at work will not be generally permitted to recover workers' comp, even if they miss work as a result, because the flu is not intrinsic to most workplaces. For a law firm, an accounting firm, a factory. The exception to that has always been, of course, the healthcare industry. So there have been cases historically where healthcare workers, nurses who work on a highly contagious floor or ward, their claims for workers' comp, if they come down with that illness, have been recognized because it is intrinsic to that workplace. So as it relates to COVID, that issue is still open. And I know not surprisingly, the workers' comp insurance industry has been saying, oh, no, our policies won't cover that except maybe in healthcare. And there's been a push as a matter of public policy and legislatively to try to require that coverage. Don't know where that's going to come out. I know a number of states have passed laws that say, I believe they've all been applicable to the healthcare industry, that says whenever a healthcare worker is diagnosed with COVID, it will be presumed to be coming from the workplace and intrinsic to that work. But I don't know of any legislation that has affected non-healthcare industry, and I don't think anything's been passed in Massachusetts yet. So that's really still an open issue, and that's going to have a great effect on the question of, will there be liability for employers if their employees get COVID? A lot of that's going to turn on how that workers' comp question goes.
And it may turn on how well they take care to mind the precautions necessary. So.
Absolutely. And again, that's a good point. The greatest protection they can give themselves to any future liability would be follow the CDC rules, follow the state and local guidelines, use the best practices throughout.
Yeah. So thanks, David. I want to take just a few minutes to talk about remote working, since it's definitely a related topic. In that, 2019 remote working was becoming more and more popular. 2020, it's now necessary. And we are hoping 2021 remote working is not as necessary, but it's clearly something that is going to be around. It's going to be here to stay, especially in some industries. So I want to talk about how, before getting to how you can go about developing a remote working policy, I just want to touch on a few tangential questions. Some are related to what David already talked about, but I think they're important when you're thinking about remote working. And the first question is what to do when an employee refuses to come back into the workplace. And this has been a common question from clients over the past 7 months. And there are a lot of issues to balance here. There's the business needs, ADA, OSHA, employee morale, personal beliefs. But the fact is that absent a specific health-related reason, an employer is permitted to require an employee to come into work, even if the employee has a generalized fear of being infected by the coronavirus. As David discussed, there are OSHA factors at play here. Further, the ADA may permit reasonable accommodations for employees with certain conditions. The issue then becomes harder for employers when an employee is concerned about perhaps infecting an elderly parent who happens to be living with the employee. Again, there's no direct OSHA or ADA protection here, but it still may be in the employer's best interest to permit continued time off or remote working for the sake of the employee and morale within the company. You also have, and David touched on this, you have the issue of high-risk employees. People want to work, but you as the employer, you as the HR rep, whatever position you're in, you may have a fear for certain folks who have pre-existing conditions or work over the age of 65 or over the age of 70. But you can't make that blanket decision that every employee with a pre-existing condition or every employee over the age of 70 has to work from home until they're secure. You can provide that option, and this might be one of those things you consider when you're developing a remote working policy, if you are going down that route. One item I wanted to touch on that, home working is extremely industry dependent. Those of you in manufacturing, retail, hospitality, really don't have the option for a majority of your workforce to work from home. But many other industries, especially professional services, can. So keep in mind that this is by no means a one-size-fits-all situation. And so if we go to the next slide, talk about remote working policies themselves. One thing I would strongly recommend is if you are going to give the option for employees to work from home, I would develop a written policy. I think there's too much room for error, too much room for discrepancy if you try to do one-offs for remote working. You want to get the buy-in for every manager who will be impacted in terms of whether that manager's employees are going to be given the option of remote working or not. And in order to do that, you kind of have to get ahead of it rather than wait for all the requests to come in. A few of the questions you'll have to answer are, is this an all remote situation or a partially remote situation? In other words, is this one of those, are you going to be, a lot of the tech companies out in San Francisco in which you give the option to everyone? Or are you going to give the option for everyone to stay 5 days a week at home? Or is it one of those situations where you give flexibility so that people could be working from home 3 days a week, perhaps if they have students who are undergoing hybrid learning in the schools? You also have to think about, is this going to be a permanent policy or a temporary one? We don't know how long, the impact of COVID is going to last. So, although you want to be thinking about the post-COVID world, you also have to really think hard before you establish a permanent home working policy, because things may change and you may realize that this doesn't work for your company. And so it's probably in your best interest to put kind of defined limits in terms of, we are going to have this policy until March 31st, 2021, whatever the date you want to pick. But the reality is that, they've done studies. 2/3 of companies out there have stated that they have found 75% of their workforce can work effectively from home. So if you run the quick math on that, I mean, it ends up being almost half of the employees out there could work from home. It's a striking number to me, and and therefore there's going to be a demand for remote working, especially now that your employees are used to doing it. When you establish a remote working policy, you want to do it on a position by position basis. You don't want to do it on an individual by individual basis. In other words, you don't want to pick, one administrative assistant to be able to work from home and the other not. That is, again, going to be one of those areas where if you have inconsistency, it could lead to potential discrimination claims. A lot of clients are using seniority, which is often a great way to provide. You want to provide those people who've been with you for a while and you trust and who you know are good workers more flexibility. But you want to be careful in, doing this could cause strife among the employees, and you also lose some of that mentorship if every single person who happens to be working in the office has only been there for a year or two. So again, seniority can be an aspect for who you offer it to and not, but you got to watch out for differing impacts. I've found that this is actually a time when people are thinking about remote working policies. This is a time when employers are also rethinking their vacation PTO, whether they want to have separate vacation, personal time, sick time, as they may have done for decades, or is this the time to go to an all-in-one PTO time? Remote working has issues with employees believing it to be a little easier to take a few hours off in the middle of the day to run an errand or to take care of an appointment. So you need to decide on how reporting of PTO is going to work in a remote environment, or else you're going to have productivity issues, obviously. Health considerations, like I said, you can't mandate that certain people work from home based on health considerations, but this could be one of the factors in terms of giving people options. Out-of-state workers is becoming a particular problem for Massachusetts employers. In other words, a lot of you probably have employees who live in New Hampshire or live in Rhode Island, who live in Connecticut. And if they are working from home, they could all of a sudden be considered to be employees in those states. In other words, employment laws, tax laws, et cetera, of those states could apply to them and to you because they are working remotely. And you always have to consider issues of precedent. You can't consider any requests for remote working in isolation because surely others are going to want to follow suit, and you have to have legitimate reasons why you will permit some employees to do it and not others. A few other things to think about with the remote working policy on the next slide. One is overtime FLSA. So if your workers are salaried and exempt from overtime, this shouldn't be a big issue. But if they get paid by the hour and are eligible for overtime, you may find yourself with FLSA issues because even if you instruct your employees not to exceed 40 hours a week, you still have to pay overtime if they actually do work more than 40 hours. And keeping tabs on their working hours is significantly more difficult when they're working from home rather than they're in the office. So you have to make sure you have a system in place to track hours because, again, the only witness to how many hours that employee worked is now that employee. And so, one option is also setting hours when the employee should not be checking emails or working. In other words, be explicit in terms of these are your working hours and there's some hours you can't work. confidential information, both protecting company information, protecting client or customer information becomes more problematic when you have remote working because people have documents at home. People are saving documents onto personal computers. So, you know, you need to establish a process, a procedure and a policy as to what employees have access to and what they can download on their computers, et cetera. And you surely should have a policy that they can't be conducting business in public spaces or on public Wi-Fi's or networks. You know, and this leads to, you may want to consider IT system checks. In other words, make sure you know what security the employee has at his or her work home office, because you don't want to find out after the fact that they were susceptible to a breach. Finally, just restrictive covenants. There have been a lot of questions about whether if you have furloughed employees and they're coming back, or if they're coming back and working on in a remote environment, do you have to have them sign new non-competes, new non-solicits because of what's called the material change in circumstance, material change in employment doctrine in Massachusetts? Probably not, but you want to think about this. If someone's coming back from being out and in a new role of some sort while remote working. If we go on to the next slide, remote workers, you also have to consider what you as an employer are going to pay for. What are the necessary business related expenses, whether it's a printer, whether it's upgraded internet connection. These are the considerations, and it may depend on whether your remote working is optional or not for that employee, but it is likely that the employer is going to have to cover some expenses, although certainly not all. Dress code, I don't think I have to say much about that, but I'm sure all of you have been on Zoom calls where dress code is wildly, you know, there's a broad spectrum in terms of what people wear, I'll put it that way. And so you probably need to have a dress code within your remote working policy. There's also some who think that unless you are dressed for work, you're not actually going to be working. So finally, the last couple bullets are related to employee retention and morale. When you're in a remote working environment, you have to keep in mind that there's going to be less informal review, less informal mentoring, and therefore you surely should maintain and keep, and if you don't have them already, start to do formal reviews so that people know how they're doing, and also to make sure that employees feel a connection to the employer. You know, you want to make sure the manager's on the same page in terms of both allowing remote working and then also how they're going to provide feedback to your employees. So with that, I'll turn it over to Natalie, who's going to talk about the FFCRA for a few minutes.
Great, thank you, Chris. So I'm Natalie Capilazzo. I'm going to be discussing the FFCRA, the Families First Coronavirus Response Act. I'll give a quick overview summary of sort of the mechanics of both the emergency FMLA provisions and the sick leave provisions, and then also provide a brief update on some of the changes that we've seen recently to the FFCRA. So the Families First Coronavirus Response Act requires certain employers, those with fewer than 500 employees, to provide expanded family and medical leave and paid sick leave for specific reasons related to the coronavirus. Both expire on December 31st of this year, so just something to keep in mind. It's now a limited duration unless something changes in the next couple weeks or months. So the expanded FMLA leave portion of the Act allows an eligible employee who is unable to work or telework, and that's sort of critical, the employee can't be able to work remotely, to take up to 12 weeks of job protected leave to care for a child whose school or place of care has closed because of COVID. The first 10 days of the leave may be unpaid, and during that time, employees can elect to use other accrued paid time off that they have from the employer's policy, whether it's vacation, personal time, sick leave during that initial 10 days. After that, the employer must pay an employee a rate of 2/3 of their regular rate of pay for the number of hours that the employee would otherwise be scheduled to work. And the paid leave entitlement is limited to $200 per day and $10,000 in total during that aggregate 10-week period. So Emily, if we could go to the next slide, please. The Emergency Paid Sick Leave Act requires covered employers to provide employees with 2 weeks of paid sick leave where the employee is unable to work because of one of the following reasons that we see here. So subject to a quarantine or isolation order, advised by their healthcare provider to quarantine, experiencing symptoms, caring for an individual who's isolating, or caring for a child whose school or place of business is closed. And again, that goes back to also the FMLA that we just discussed. And then an employee is experiencing a substantially similar condition. And we still don't have additional guidance from the Secretary of Health and Human Services what that might mean. So that one's sort of just still up in the air for now. The rate of pay is, for reasons 1 through 3, full pay up to a cap of $511 per day. Reasons 4 through 6, 2/3 the regular rate of pay up to $200 a day. And then just one note, the paid sick leave is specific to COVID-19 and the pandemic. It's separate from other forms of paid leave. So an employee's ability to take this leave does not impact their other leave entitlements that they have under state law or the employer's policy. So then, Emily, if we could just go to the next slide, just some recent developments to touch on. In April, the state of New York filed a lawsuit against challenging certain aspects of the FFCRA. And then as a result, the Department of Labor issued some additional guidance and revisions to the law on September 16th. So one of those changes is to clarify that the healthcare worker exclusion applies to an employee who is we can see these 3 categories here: a licensed doctor, a nurse practitioner, other provider, someone who's employed to provide diagnostic services, preventative services, or treatment, or employed to provide services integrated with and necessary to the provision of patient care. So the goal of this change is to clarify that the healthcare worker exclusion should really only be reserved for those employees who are providing healthcare. It doesn't extend to janitors, other administrative professionals, sort of workers who are ancillary and not totally related to the provision of healthcare. It really sort of narrowed that definition to who should be excluded from these leave entitlements. And then just a couple of points on how we're seeing this impact questions related to return to school. The FFCRA provides that leave is available on days when the employee's child is not permitted to attend school in person and must attend remotely. So in a hybrid situation, on one of those days where it is the child's day to be at home and there's no other childcare available, leave is allowed. And on the flip side of that, it's not available where an employee elects to have the child attend school purely remotely when in-school learning is an option. So in that scenario, the school is not closed due to coronavirus, so there is no leave entitlement there. And then just a couple of other changes to touch on. Now, if there is work available for the employee to do, but they can't because of one of those qualifying reasons, then they are, so if there's work available, but one of those reasons applies, the standard is now but for. If if the employee's on furlough because there's no work available, they are not entitled to leave now. And that used to only apply to reasons 1 through 3. Now it applies to all reasons. Just a couple changes to notice and documentation requirements. The notice that the employee is going to take emergency family medical leave is now must be given as soon as possible. It used to be prior to the leave, but that was kind of restrictive in situations where it wasn't immediately clear prior to taking the leave that leave was necessary. So it adds a little bit of flexibility there. Same thing with documentation supporting the need for those leaves. It's again, as soon as practicable. Same thing, it used to be that this had to be provided to the employer prior to the leave, and now it's as soon as possible. And then just to note, the new regulations clarify that intermittent leave still requires employer consent. So that is the case under the FMLA, and the Department of Labor has clarified that that is still the case with this emergency expanded family and medical leave. So now I'm just turning it back to Chris so that we can hopefully run through a few questions.
Thanks, Natalie. So it's almost 5 o'clock, so we're probably going to go over by a few minutes for questions, but understandably it is 5 o'clock. So if you would like to drop off at any time, please do not hesitate to. We will not be offended. We've had a couple questions about if you are permitted as the employer to, if almost all of your staff is remote, but you want to have maybe a once a week meeting among specific departments, kind of a strategy meeting. So in other words, you're bringing back just a few people in one department for 1 day a week. A, can you do that? In other words, can you require some people to come in 1 day, but not others? And the answer is yes, if it meets the business needs. Obviously, you have ADA and OSHA considerations, but as long as you meet those, you're fine. But then the other question is, do you have to follow all those testing, screening guidelines, Emily, if it is just a occasional once a week meeting and it's only a few people coming into the office?
Yes, under the Massachusetts guidelines, it's a requirement that employers have to screen employees prior to coming into the office. There's also some requirements about meetings with multiple people, such as, you have to wear a mask, maintain the 6 feet between everyone. Meetings are discouraged and encouraged to be held remotely. And then after the meeting, it's encouraged to clean and disinfect that conference room that you were in. So, your operations people are going to want to be notified of the meeting and log everybody who came in, et cetera, for contact tracing purposes. So even if it's, even if your office is closed technically, if you're going to be having people come in, you still have to follow those guidelines. Great,
thanks. David, a question for you. Can an employer discipline an employee who repeatedly reports to work with COVID-like symptoms or refuses to wear a mask?
Yeah, absolutely. I don't think there's a question. I mean, if they refuse to wear a mask, or if they, or if they come to work and they're symptomatic, and you've told people don't come to work if you're symptomatic, I think not only can you, but I think you have to. You can't let them at work. You have to send them home, and if they keep doing it, I think you have to discipline them and terminate them potentially.
All right. Since you thought that question was easy, I'll give you a harder one, David. You mentioned that it would be violation of confidentiality rules to disclose the name of the individual who may be COVID positive. But if it doesn't, if COVID-19 is not considered a disability under the ADA, how would that be an ADA violation?
Because that's a good question. Because the way the law is written, the confidentiality rule is written, it's all medical information is confidential. It doesn't have to be disability related information. It's all medical information, meaning that even the temperature that you may take of an employee when they come in the door, that information is confidential. That employee, that the employee came in at 98.6, that's confidential information. Anything like that, regardless of whether it's related to a disability or not, is medical information must be held confidentially.
Okay. Natalie, one for you. If there are multiple, if there are repeat government shutdowns or school shutdowns, and people need under the FFCRA to take, can they take repeated 2 weeks of coverage, or is it just a one-shot deal? And what about the 12 weeks of coverage?
So part of it depends on the reason for the need for leave. If it's an instance of a school shutdown and we're in the world of the expanded FMLA, that is permissible up to that 10-week allotment, really. So even if it is staggered, the DOL has made clear that when a school is shutting down, that's not the decision of the employee, that's on the school. And so when that employee needs leave because of a shutdown, it's, has to be provided up to that 10-week allotment. And it's actually clear that even though this sounds like and feels like an intermittent leave, it's actually not, because it's at the direction and discretion of the school or the agency who's conducting the shutdown. So employer consent is not required in those situations.
A question about remote working, so I'll ask it to myself. Someone has asked, should we update our job descriptions to include whether the job can be performed remotely in order to avoid potential discrimination claims by applicants? And to me, the answer is you should. Perhaps more importantly, you should include in your job descriptions if the position cannot be done remotely, just to make it clear to people that they would have to come into the office or the workplace in order to conduct the job. I don't know, either David, Emily, if an employee is injured at home while working remotely, would that fall under workman's comp?
I say, yeah, I think. And I think that employers, and it's a good question, because I think when you start to put a remote work policy in place, it might make sense to contact your comp carrier to make sure that you have coverage is appropriate.
Maybe our last question, I'll open it up to the group too. If you're a service provider, perhaps you provide IT services to other companies, or if you provide cleaning service to other company, what's your responsibility, do you think, as the employer, if you're sending your employees to another workplace to actually perform their job? Obviously, it's going to be a tricky situation, because that employer that office space or that workspace is your client. So you may not want to be too heavy-handed, but do you have to be in order to make sure that your employees have a safe working environment? Anyone have any thoughts on that?
I mean, that's a really great question. Under the Massachusetts guidelines, it's the operator of the space that is responsible for maintaining the safety standards. So, like a subtenant in a building is responsible for their own space, and then the landlord covers the common areas. When you're sending your employees somewhere else, you can require them to do certain things, but I think to a certain extent you're relying on other people and your clients to maintain safety in their facilities.
Okay. So there are a number of other questions that people have asked, but I am cognizant of the time. So I will make the promise that we will, if you so desire, we can answer all of these questions directly to the people who submitted it in the next coming days. And so, but before we let everyone go, I just wanted to touch on, we do have some upcoming events that are pretty remarkable. The first is happening this Friday, conversation with Mayor Marty Walsh, as well as Dr. Carolyn Crockett, relating to equity and racial justice in the city. So I highly encourage everyone to attend that program on Friday. And then as well, next week, you may have forgotten paid family and medical leave because COVID has kind of taken over the last 7 months, but remember that it does kick in on January 1st. You know, to the extent you aren't already prepared for that, you should be. And we have a great opportunity to hear from the director himself of the Department of Family and Medical Leave next Tuesday at 12, Bill Alpine, on that subject. So to the extent you want a refresher on what PFML meant to you all, please come and join us for that. But unless anyone has any other comments, the panelists, I thank everyone for joining us today, and we'll see you again soon.
Thank you.
Thank you.